Hi everybody and welcome to the legal education. In these videos I'm going to discuss mistake under section 20, 21 and 22. Please listen carefully and if you have any questions please comment in the below and kindly subscribe to my channel. Okay, well, let's get started. We have already discussed free consents under section 14, section 15, section 16, section 17, section 18. In these videos I'm going to explain mistake under section 20, 21 and 22. Section 20, 21 and 22 deals with the concept related to mistake. Mistake can be defined as any action, decision or judgment that produce an unwanted and unintentional result. A mistake is said to have occurred where parties intending to do one thing by error do something else. You have to know that a mistake is of two types, that is mistake of law and mistake of fact. Again, mistake of law can be of two types, mistake of Indian law and mistake of foreign law. Again, mistake of fact, there are three types: bilateral mistake, unilateral mistake, common mistake. I'm going to discuss all the point. Mistake of law. Mistake of law means any contract which is performed by parties without knowing the law or by ignoring the law, which is essential for that contract. Section 21 of the Indian Contract Act deals with the effect of mistake as to law. So mistake of law can be two types, that is mistake of Indian law and mistake of foreign law. So mistake of Indian law, we know ignorance of the law is not excuse. So if a person take a part in a contract without knowing any specific provisions of Indian law, which is essential for that contract, then contract is not voidable because everyone is supposed to know the law of his country. I'm going to show you an example. Suppose Mr. A and Mr. B. Mr. A murder B. A cannot apply for the defense of mistake of law. So he cannot say he is not aware of law related to the murder. So in case of mistake of law, ignorance of law is not excuse. A will be punished. But in case of mistake of foreign law, if a person take a part in a contract without knowing any specific provisions of foreign law, which is essential for that contract, then that mistake is treated as a mistake of fact. That is, the contract is void if both the parties under a mistake as to a foreign law, because one cannot be expected to know the law of other foreign country. So in Indian law, mistake of Indian law and mistake of foreign law is not same. So number two is that mistake of fact. Mistake of fact means any contract which is performed by parties without knowing any material fact or ignoring the fact, which is essential for that contract. Section 20 and 22 of the Indian Contract Act deals with mistake of fact. Mistake of fact is of three types, that is bilateral mistake, unilateral mistake, common mistake. Now in case of a mistake of facts, suppose now A is the officer, Mr. A is the officer of the court and he is ordered to arrest Mr. B. A arrests Z by mistake as he believes Z is B. Here A can take the defense of the mistake of fact. So in case of mistake of fact, there is an excuse. Bilateral mistake, according to section 20, where both the party to an agreement are under a mistake as to a matter of fact essential to the agreement will be void. In simple words, if a party are involved in agreement without knowing any essential fact related to the agreement, then it is considered as a bilateral mistake and that agreement will be void. But in case of unilateral mistake, according to section 20, a contract is not voidable merely because it was caused by one of the parties to it being under a mistake as to a matter of fact. Such a mistake does not invalidate the agreement. For example, Mr. A and Mr. B made a contract in which only A was under a misbelief for any product which is in the transaction, then the contract is not voidable for A and will be classified as a valid contract. Cases in which unilateral mistake make a contract void and voidable. The last one is a common mistake When both the party are mistaken for the fact related to the subject matter of the agreement, the court can declare the entire agreement as a void in such a kind of mistake. I hope you people are understand mistake under section 20, 21, and 22. We have already discussed coercion, undue influence, fraud, misrepresentation, mistake. So we have completed free consent under section 14 to 22. So see you in the next class. Thank you.